Hello everyone, welcome to Achievers IAS classes. Today we are starting the discussion on the most important events of the year 2018 and thereby touch upon several issues on different themes which are also very important from the interview perspective. We are planning to do this in a 4-part series with the first part now covering the months of January, February and March. So let's start with the first issue regarding the unrest in Pune, Maharashtra, which has resulted in violence in many parts of the states. It all started when a group of Mahars, who are considered Dalits in Maharashtra, gathered at Bhima Koregaon to celebrate the victory of the war which took place in 1818, which led to the defeat of Peshwa Bajirao II by the British. There are various views expressed by different communities over the war, and that is the reason for the whole unrest. Some see it as a war between the Dalit Mahar community and the Brahminical Peshwas, when it was actually was the war led by imperialist British against the local Peshwas. In this regard, a point to be noted is the war of 1818 was not between the Dalit and Brahmins, but the British used the Mahars for their advantage. The Mahars saw it more of a employment rather than venting out their anger against the Brahmin community. But this was tweaked by a few Dalit leaders to mobilize support for the cause of Dalits. But now, given the widespread unemployment and the lack of educational opportunities of the Maratha youth, the society has been polarized by various right-wing organizations, thereby resulting in the violence. The next important issue was regarding the movie Padmavat, which had given rise to a major controversy. The Supreme Court had stayed the notifications and orders passed by various states like Gujarat, Rajasthan, Haryana, etc. to prohibit the exhibition of the movie Padmavat. The court in this regard ordered all the states to ensure that law and order situation is maintained during the screening of the movie, which has already been cleared by the Central Board for Film Certification. This was in response to the plea filed in the Supreme Court by the filmmakers against the orders given out by states like Gujarat, Rajasthan, etc., citing that the movie hurt the religious sentiments of the people, as many groups protested against the portrayal of Queen Padmavati in the movie, which is basically the story between Maharaja Ratan Singh of Mewar and Sultan Alauddin Khilji of Delhi. What the Supreme Court has pointed out in this case is the state cannot choose between protecting freedom of expression and preserving law and order, but it is the duty of the state to do both, thereby staying the notifications of several states to prohibit the screening of the movie. The court found that stifling of creative freedom under the guise of possible risk to public order is troubling because summary ban on movies violate the freedom of speech and expression guaranteed under Article 19 of the Constitution. Further, the court observed that even though the right to freedom of expression is subject to reasonable restrictions with respect to maintaining public law and order, the use of threat of violence and other forms of intimidation cannot be cited as a reason or a reasonable restriction to maintain peace. This is in line with the past orders of the Supreme Court too, where the court said the state cannot plead inability to handle the problem of hostility, as that would amount to the violation of rule of law and surrender to the blackmail and intimidation of the state. And it has reiterated that the state has no power to prevent the exhibition of a movie once the CBSE has granted certificate for the same. Coming back to the current controversy, the filmmakers had already agreed to change its name from Padmavati to Padmavat, indicating that it is based on a medieval poem rather than the legendary Rajput queen. They had also agreed for several cuts suggested by the special panel formed by the CPFC. If even after all these concessions, the protesters are allowed to obtain a ban, then it is nothing but surrender to blackmail and intimidation and would taint on the country's record of protecting free speech based on charges of people who have not even seen the movie and find it offensive. Therefore, the Supreme Court has rightly indicated the constitutional duty of the state in this particular matter. With that, Let's move on to the next issue in news. The next important issue was regarding a woman named Hadiya in Kerala, in which the Supreme Court directed to the National Investigation Agency in the Hadiya case to stay away from investigating into her marriage choice. This comes in the backdrop of the argument put forward by the NIA that Hadiya was indoctrinated, radicalized, and brainwashed to convert from Hinduism to Islam before her marriage. The court, in this regard, has said that it cannot question her choice, and as an adult, she is free to decide who her marriage partner will be without any threat or force. On that note, let's move on to the next issue, which is regarding the annual status of education report for the year 2017. The report has brought out various interesting facts by focusing on youth in the age group of 14 to 18 years of age. The ACR 2017 report is different from the previous ones because it employs a wider set of domains beyond just foundational reading and arithmetic in an attempt to capture the status and abilities of youth in this age group. Also, the previous ASER reports generated estimates at the district, state, and national levels, but the ASER 2017 has generated only district level estimates. Some of the important findings of the report include 36% of the children surveyed did not know that Delhi was the capital of India, and 14% of the rural youth in the age group of 14 to 18 years failed to identify the map of India, and a staggering 79% of them only could answer which state do they live in, thereby throwing light on the quality of education till so far not seen dimensions. Coming to the school enrollment of the children in the age group of 14 to 18 years, the report has revealed that only around 14% of them are not currently enrolled in any school or college, but this percentage varies a lot with age, highlighting that at the age of 14 years, only 5.3% of the children in the age group of 14 to 18 years are not enrolled, but by the age of 17, this percentage almost quadruples to 20%, which in the Indian scenario translates to large number of youth who are not in the formal education system. The report further highlights the difference in enrollment rates between boys and girls, which stands at 32% for girls as against 28% for boys in the age group of 14 to 18 years. Finally, the report states that about 25% of the children in this particular age group still cannot read basic texts in their own language, and more than half struggle with basic division, thereby highlighting the shortcomings in our educational system and the lack of quality at different levels of education. The next important news was regarding the government's decision to allow the re-entry of commercial mining in the coal sector. India's coal industry was dominated by the private sector after independence until the Indira Gandhi government enacted the Coal Mines Nationalization Act, which was then seen as a key to meet the power needs of the country. This move resulted in a virtual monopoly in the coal sector for the public sector, and Coal India currently accounts for over 80% of the country's coal supply. Apart from some captive coal mines allotted to the private players for specific end users like steel manufacturing, power industries, etc., the participation of private players in the coal industry was virtually absent, and the current reform to allow commercial mining was a long pending reform because of India's high dependence on coal for power generation. The move is also significant because in recent years there has been an increase in the imports of coal, even though the country has rich coal deposits, because Coal India has been unable to keep pace with the rising demand for coal. Also, the Supreme Court's cancellation of the allocation of coal mines to public and private players in 2014 severely curtailed supply of coal in the market. But the government then moved swiftly to bring in a transparent auction process to ensure that there was no supply shocks for power producers due to disruptions in mining operations. As a follow on, the current step by the government to liberalize the coal sector will boost energy security of the country, making coal more affordable and creating more jobs in the sector. However, the government should exercise caution that the coal blocks allocated to the private players should not just be the ones on which Coal India isn't keen on exploiting, but should be of good quality. Adding to this, the integrity of the process as well as minor safety should be simultaneously looked into. Having said that, let's move on to the next issue, which is regarding the State of the Forest report released by the Environment Ministry. The document says that India has about 21.53% of its geographical area under forests, which also includes substantial patches of trees outside areas designated as forests, such as plantations or greenlands, because it is the long-standing goal of the government to bring at least 33% of its area under forest since 1988. The report further highlights that the states of Andhra Pradesh, Karnataka and Kerala have posted an increase in the forest cover, and currently 15 states and union territories have 33% of the geographical area under the forests. It further highlights that the category of very dense forest, defined as a canopy cover over 70%, which is an indicator of the quality of forest, saw a dramatic rise, but the category of moderately dense forest has declined from the year 2015. An important point to remember from the prelims perspective is India is ranked 10th in the world with 24.4% of its area under forest and tree cover, even though it accounts for only 2.4% of the world's surface area and sustains the needs of 17% of the human population and 18% of the livestock population. The various facts mentioned in the report are very important, as previously questions have been asked on the same as well as on the government's efforts to improve the forest cover, and therefore I request you to go through the issue in detail. The next topic of discussion is the budget of 2018-19. At the outset, the budget of 2018-19 seems to be focused on improving rural economy, decreasing the vulnerability of the poor, and other measures catering to the social sector. Firstly, responding to the distress in the agricultural sector in various states across the country, the government has decided to offer a minimum support price of 1.5 times the expense of cultivation of these crops. Towards this end, the Niti Aayog, in consultation with the central and state governments, will put in a foolproof mechanism so that the farmers will get adequate price for their produce. To address the price volatility of perishable commodities such as potatoes, tomatoes, etc., the government has launched Operation Greens to promote farmer producer organizations, agri logistics, processing facilities, and professional management in the sector. The government has also proposed raising the institutional credit for the agricultural sector from 10 lakh crores to 11 lakh crores in the financial year. In an effort to boost organic farming, the finance minister said that women self-help groups would be encouraged to take up organic agriculture in clusters under the National Rural Livelihood Program. Also, a sum of rupees 200 crore has been allocated to support organized cultivation of highly specialized medicinal and aromatic plants that are used by small and cottage industries to manufacture perfumes, essential oils, etc. Apart from all this, the finance minister has also announced that around 22,000 rural huts or local markets would be upgraded into Grameen agricultural markets, thereby empowering small and marginal farmers. Adding to this, the government would also strengthen the electronic national agricultural market to create a common platform across the country. Also, an agri infrastructure fund will be set up for developing and upgrading agricultural marketing infrastructure in these agricultural markets. With an aim to encourage the food processing industry, the government has also doubled the allocation for the sector, which will promote the establishment of specialized agro-processing financial institutions as well as state-of-the-art testing facilities in the mega food parks. Further, to meet the working capital needs of small and marginal farmers in the fisheries and animal husbandry sector, the government has extended the facility of Kisan credit cards through which farmers can benefit from crop loan and interest subvention, so far only available to the agricultural sector. Also, the finance minister has announced setting up of Fisheries and Aquaculture Infrastructure Development Fund and an Animal Husbandry Infrastructure Development Fund for financing the infrastructure requirement of the animal husbandry sector in the economy. The finance minister also announced a restructured national bamboo mission on a cluster-based approach to promote the bamboo sector in a holistic manner. Finally, to address the challenge of air pollution in Delhi and the National Capital Region, the government proposed that a special scheme will be implemented to support the efforts of Haryana, Punjab, Uttar Pradesh, and the National Capital Territory of Delhi to subsidize machinery required for in situ management of crop residue, which is currently being burnt by the farmers, greatly affecting the air quality in the region. I intentionally discussed the various provisions for the agrarian sector in the budget due to the widespread agrarian distress on which a question is likely during the interview. As you are already aware, even in the mains examination, a question was asked on the budgetary provisions on the taxation front. Therefore, go through the budget in detail as it may come in handy. The next issue was regarding the Khap Panchayats. The Khap Panchayats have been in news for all the wrong reasons, ranging from restrictions on women's code to honor killings. And recently too, they were in news as the Supreme Court has said that the Khap Panchayats have no role in interfering with the life choices of individuals regarding marriage and love. The court has observed that the Khap Panchayats should not act as conscience keepers of the society, which reflects the medieval feudal mindset. In 2011 too, had termed the Khap Panchayats as kangaroo courts and wanted them to be stamped out from the country. Even after such repeated observations by the Supreme Court, it is a grave misfortune that parents continue to use coercion and harassment and even resort to murderous violence to enforce their feudal prejudices, which in essence is choosing familial honor over human rights. What's even more disturbing is even educated and presumably socially advanced sections too resort to such violence to enforce age-old taboos such as prohibition of marriage between individuals of the same gotra among Hindus. Such views can only be eradicated with the change in social attitudes, but there is also need for a law to be put in place as recommended by the Law Commission in 2012, which seeks to address the problem of Kap Panchayats by treating them as unlawful assemblies and decisions of these assemblies that amount to harassment, social boycott, incitement of violence, etc., to be punishable with a minimum sentence. Ultimately, whether the solution is through social transformation or through legislative change as suggested by the Law Commission, the feudal institution of the Khap Panchayats demand no sympathy in a modern society and have to be stamped out. On that note, let's move on to the next issue, which is regarding the various scams which broke out in the banking sector. As we know, just days after the news of the 11,500 crore scam broke out from the Punjab National Bank, there was yet another case of willful default which was reported. Both these cases have certain similarities in that there is a breakdown of internal control mechanisms and the supervisory failure of banks. With the difference being, in the willful default case of Rotomac, the company was already listed as a top defaulter almost a year ago, and the account had been classified as an NPA long back, which was not the case with the scam at Punjab National Bank. Still, the banks failed to take remedial measures against the promoters of the Rotomac company. In this regard, it is very important to determine why the Reserve Bank of India, which is the regulatory watchdog, was unable to take prompt corrective action in this case. Therefore, as it has been told many a times in the past, the center, which is the major stakeholder in these institutions, should take serious steps to infuse greater professionalism, transparency, and accountability in these institutions by empowering bank managements and securing their independence. Because failure to restore the depositors' faith in the banking system is going to result in a huge economic cost and negatively affect the nation's growth. The next issue is regarding the landmark judgment of the Supreme Court upholding passive euthanasia. The Supreme Court has upheld passive euthanasia as well as the right to give advance medical directives, or what we call as living wills, to smoothen the dying process as the part of the fundamental right to live with dignity. Passive euthanasia as such was recognized in 2011 itself in the Aruna Schonbach case, who we know was confined to a vegetative state post a brutal physical abuse. As an extension, the current judgment of the Supreme Court has expanded the scope of passive euthanasia by adding the principle of living will or an advanced directive whereby a person who is in a competent state of mind can leave written instructions on the sort of medical treatment that may or may not be administered to him in the event of his or her stage of terminal illness. For further clarity on the issue, let's just look into passive euthanasia and living will separately and in detail. Euthanasia is classified into two different types basically, that is active euthanasia and passive euthanasia. While active euthanasia involves administering of a lethal dose of drugs to cause death, passive euthanasia on the other hand is an act of withdrawing or withholding medical support to a terminally ill patient. The current Supreme Court judgment has interpreted the right to die with dignity as a fundamental right under Article 21 of the Indian Constitution. The court further said that dignity of a man is lost if the person is allowed or is forced to undergo pain and suffering because of unwarranted medical support. Because the hope of recovery of a terminally ill patient or a person in a permanent vegetative state is almost negligible. Therefore, accelerating the process of death for reducing the period of suffering of the individual constitutes a right to live with dignity of the individual. The court further highlighted how societal pressure and fear of criminal liability by the relatives of an individual and doctors has led to suffering and undignified deaths, thereby giving a legal status to advance directives in which the right to a dignified life is as determined by an individual in a competent state of mind. An advance directive is a clear set of instructions given by a person to withhold medical treatment in case of terminal illness in the presence of eyewitnesses. This document shall be preserved by the magistrate, which will be enforced at an appropriate time by the person mentioned as a custodian by the individual in his living will. This living will provide safety to the treating doctors by assuring them that they are acting lawfully in respecting the patient's wishes. Although the government submitted that it is in the process of introducing a law to regulate passive euthanasia, but it opposed the concept of advance directive on the ground that it was liable to be misused. But the court justified its opinion on advance directive, saying that it only reflects the patient autonomy and does not amount to a recognition of a wish to die. On that note, we are wrapping up today's discussion. Do like, share and comment to support this initiative. Thank you for watching. Have a nice day.